Okay, let me start. So yesterday we were discussing judicial review, right? And we were discussing what are the tools and regarding how do the judiciary functions while they are interpreting the law, and what is the function of the judicial review and how was it revived. And we were discussing that how the judicial review functions when it comes to administrative actions as well as legislative actions. So yeah, can we just move on to the next slide? Yes, we were to discuss this case, A.K. Gopalan versus State of Madras. In this very case, am I audible? I think there is some network error. Am I audible? So as we know, am I audible? Okay. So in this case, now it's fine. Yeah, in this case, the Supreme Court discussed the logics behind preventive detention. So primarily, what is preventive detention? So preventive detention means that while you are, for example, habeas corpus, because preventive detention is done by the state whenever there is some possibility of somebody creating some terror, or there is some information that that person could be indirectly or directly a threat towards the state, then the government and the agencies can take an action against that individual and keep him as in a preventive detention. So in this case, it was held, the Supreme Court ruled that the state agencies was permissible as long as it was provided for a governmental measure, that is legislation or an ordinance, and the court could not inquire into the fairness of such measures. It was held that procedure established by law were different from substantive due process. So we have two intricacies here. One is procedure established by law, and second is substantive due process of law, right? So one says that whatever is written should be followed, and one says that proper procedure should be there and then things should be followed. Okay, so they were different from this guarantee provided under 14th Amendment to the US Constitution. So the similar provision we copied from US Constitution. It was also reasoned that framers of Indian Constitution consciously preferred to former expression over the latter. Thus, A.K. Gopalan, while recognizing power of judicial review under Indian Constitution, but read in a very narrower manner, because it was read again a very narrower manner. Okay, am I clear? Am I audible? So if you can message me. Okay, yeah, okay. Yeah, so can we have the next slide? Again, in this Menaka Gandhi case. So in Menaka Gandhi, it is again highlighted that reasonableness. So in this case, what happened was primarily it was ambit of Article 21, 14 and 19 were widened. Okay, so here the passport of Menaka Gandhi was confiscated and was not given to her, and she was prohibited from traveling abroad because it was presupposed or presumed that she was going to say anything in some conference abroad against the government and its instrumentalities. Okay, so it was held, and her passport was confiscated on this reason, and she was not allowed to travel abroad on this reason, that she would presupposed or presumed to be saying in a speech or in a conversation which she was going to deliver in some foreign country. It was held that it was against the state or against the Prime Minister or the government of India. So it was held that the governmental restraints on personal liberty should be collectively tested, and the guarantees of fairness, non-arbitrariness, and reasonableness that were prescribed under Article 14, 19, and 21. 14 describes regarding right to equality, 19 talks about right to freedom of movement and speech and expression. So, and 21 again, right to life and liberty of the Constitution. It was held. The court developed a theory of interrelationship of rights. So, all these fundamental rights are either interlinked or adjoined to each other, and they should be read in one complete line and one complete lineage, so that either of the rights is not curtailed and the threshold of them is equally maintained. In this manner, courts incorporated the guarantee of substantive due process into the language of Article 21. Okay. Any questions so far? Do you understand this case? So my audio is again not clear. Okay. Is my voice clear now? Shall I repeat the case? Anybody can reply? I'm so sorry. I don't know what is wrong with this now. Am I clear? Okay, I'll repeat the case. So in this Menaka Gandhi case, AIR 1959, while she was to travel abroad, she was to deliver a speech which was presumed in a foreign country, which was presumed by this to be against the state, and her passport was confiscated and she was not allowed to travel. Okay, so thereafter she filed a case in regards to her fundamental right to travel abroad or travel was infringed. So it was held the government restraints on personal liberty should be collectively tested against the guarantees of fairness, non-arbitrariness, and reasonableness, which were again prescribed under Article 14, 19, and 21, where Article 14 talks about right to equality and Article 19 talks about right to freedom of speech, expression, as well as right to travel and movement. And Article 21 again says there is right to life and liberty, which should be read as an interrelationship of rights and should not either of the rights should not be infringed, because that might curtail any other fundamental right as well. So again, through this case, the substantive due process of law was entered into the language of Article 21. So thereafter we could, okay, you are not audible. Kajal, what do you want me to repeat? The whole case again? Am I okay? My voice is clear now, right? So I did not. Okay. So again, I would say in this case, the ambit, the scope of Article 21 again was widened, and this article again is a very, very important article in pretext of judicial review as well, because the legislative action which was done over Menaka Gandhi for infringing her right to travel and right to movement, as well as right to equality, as well as right to life and liberty, was curtailed for not allowing her to move to another country or travel to another country just to deliver a speech, which was presumed to be against the nation or against the state. But again, that infringed, that she had not yet delivered that. It was not called anti-nationalist or something, but she was not allowed to travel only, right? So it was held that all the rights should be are in an interrelation and should be read in one line, and either of them should not be curtailed, because even if one of the right is curtailed, there are many other rights who are also interlinked that would be also curtailing them. The state will also be curtailing them. Yes, please, next slide. Yet again, we have discussed this case, Keshwananda Bharti with State of Kerala, 1973. Supreme Court of India propounded the basic structure doctrine, in which it was held the Parliament has power to amend the Constitution, but it should not change the basic structure of the Constitution. However, the court failed to declare or demarcate any term of basic structure, which was again interpreted through judicial review. And through judicial review only, we have the definition of basic structure, and we have all the elements just through the judicial precedents and judgments that what is inclusive of judicial review and what does not include in, which are what conditions are there where we can do the judicial review. So in clear words, but almost all judges agreed that judicial review is also one of the basic structures, right? So relevance of basic structure is derived through this case. That through Keshwananda, we can say that judicial review is one of the most important organ, or one of the most important element of the Constitution for it to be working well. Right? Can we have the next slide? So yeah, through this flow chart, you may presume you can see there are broad types of judicial review that could be changed, which could be altered. Basic structure doctrine says only constitutional amendments could be changed. Thereafter, it would be a judicial review can challenge competency or ultra virousness of these articles, right? And rights also through narrow construction could be done. Again, Article 13, 32, and 226 talks about judicial review itself. And also it discusses regarding the interrelationship of three of the rights, that is 14, 19, and 21. That is fairness, reasonableness, and due process. Right? Can we have the next slide? Any questions so far? So basic structure doctrine was again propagated in Keshwananda Bharti case. Thereafter, before that, we had Chankri Prasad, Sajjan Singh, and Golak Nath, which were not able to demystify this meaning, but it was declared in Keshwananda Bharti case. Thereafter, in Indira Nehru Gandhi, Minerva Mills, and L. Chandra Kumar, judicial review was again upheld, and it was said that it is inclusive of the basic structure. Yes, the next slide, please. We will be discussing the basic structure in the, I suppose, the next lecture. So I'll go in detail with the basic structure and the amendability procedures in the Constitution. So I'm not touching that topic in a detailed manner right now. So in this case, Anuj Garg versus Hotel Association of India and others, that is an AIR 2008 case. Somebody yesterday asked me regarding whether we can challenge legislative acts or whether we can challenge executive actions. So here's a case for you. I'll explain this case. So listen very carefully.